starting with the State of Ohio versus Dean Pieronek. Case number 18AP0031. Both parties are represented by counsel. Each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. We have read the briefs and we are prepared to proceed if you want. Let me know if you're going to reserve time as well.
Thank you, Your Honor. May it please the court, counsel, my name is James Armstrong. I do represent Dean Pieronek, and I would like to reserve 3 minutes, if I may.
All right, I'll let you know when you get closer.
Thank you, Your Honor. A person cannot be convicted of hit and skip pursuant to 4549.02 unless the cited person collided with an individual, a vehicle, or property upon the roadway. And none of that happened in this matter. After the state's case, the court should have granted a motion to dismiss under Criminal Rule 29, because based on that testimony that was, and looking at it most favorable to the state, the section that he was charged under, actually it was amended. I think the Highway Patrol charged him under a different section, and the prosecutor changed it to this section.
What was the original charge?
I think it was maybe leaving a scene or failure to report. I can't remember off the top of my head because it was changed right away in August of the year it happened, which I think was in 17. This has been about 2 years ago. In fact, in the proffer, the state highway patrol officer was going to be called to testify and specifically stated that this was the wrong section to charge him under. And if we look at the history of this section as interpreted not only by this court, State v. Cullen, which was only a couple months before this case was decided, but if you look at all the cases that this court relied on throughout the state, the circumstances of this case has never been used under that code section. In fact, this code...
Remind me, that was the case where the car went off the road, hit a mailbox, correct?
Correct. And
is that distinguishable from this case in that the vehicle was on the roadway when it ran into the wires? It never left the road.
It never left the roadway, Your Honor, but I think what's interesting is that there was no unlawful behavior on the part of Mr. Pieronek. Nobody even in the states that he did anything improper while driving a semi-truck. I think that's somewhat of the irony here, the issue of how he could hit a line in which it's undisputed that semis are on that road on a regular basis is somewhat surprising. And they clearly tried to claim that a wire suspended over the highway is somehow on the highway. It's almost a legal riddle. When is something on a roadway when it's not on the roadway? And that's kind of what the state was trying to claim, and I think improperly based on not only the clear meaning of the statute, but all the case law that has been interpreting that statute, Your Honor. And I think that's the main reason why, if you take the state's case, everything they stated, it doesn't establish 4549.02 because we're not looking at having to contact somebody who is in another car or in maybe a pedestrian or some sort of farm vehicle, considering it was in Apple Creek and the farms that are in this area. Those things, none of those things happen.
I have a question for you, though, because I didn't glean it from your brief either or your reply brief, but I did get it from the state's brief. Was there, after he hit the wire, did the poles fall into the road?
Well, that, according to the testimony and transcript, he was surprised by that. I don't know if the poles. I don't know if the poles fell after the wire was hit, or if it happened after his dispatcher told him to move on.
But in any event, I'm just asking, did poles fall on?
According to the transcript, yes, it did.
Okay.
Did it happen immediately? I don't know, but
as a result of the wire getting hit.
Well, I'm not even willing to concede that point because we don't really have any testimony as to why the pole fell.
Okay.
What we do know, based on the testimony, is my client didn't do anything wrong while operating a semi-vehicle, which leads to believe that perhaps American Electric Power, who owned the wires, maybe did something wrong, or was there a weather circumstance? My client thought that when it happened initially, he thought lightning hit his vehicle. So that is information we do not know. What we do know is he immediately contacted his dispatcher, who was then, according to the testimony, he told him to move on. That would have been probably more developed in the course of the case had my client not been denied due process and his right to present a defense, with the improper ruling of denying him a chance to call the witnesses that had subpoenaed and been notified and served upon the state, not once, not twice, not 3 times, not 4 times, but 5 separate occasions. The 6 people were served a notice through subpoenas.
Was the dispatcher one of those witnesses?
Yes, not only that dispatcher who he initially talked to was about ready to come off, but the 3 people who were in that FedEx office that heard what he specifically told them, along with the highway patrol officer who was going to testify as what the proper section should have been to cite somebody under that. And it's somewhat unfair to sit there and say, well, you should have been cited under this, because each defense has a different way of preparing. And if you're cited under a statute that doesn't even apply to the circumstances of the case, and then you're denied the ability to present a defense based on case law that's not even applicable, I'm sorry, every time I read this transcript and look at what happened, I'm somewhat in a little bit of disbelief that it occurred.
So is it your contention then that he should have been cited under any statute or under 454903?
I think 454903 is okay. If I would have been more appropriate, if I'm not mistaken, because that's the one where you at least have 24-hour notice to notify people of the accident, if I remember my code sections properly. But even then, I would argue he did it immediately because he contacted the dispatcher at FedEx. And if there were any problems, I would submit that the dispatcher at FedEx in the office with the computers and the information is in a better position to obtain and notify the appropriate people for assistance than a truck driver in a cab in the middle of Apple Creek. That would be probably the more prudent way to try to get the information. Not only that was what he would have been instructed to do and was instructed to do, but also it just seemed to be the more appropriate way to do that, to get the people who have access to the most information, like who would have owned the power lines or whatnot, because there's not a whole lot you can do in the cab alone.
Let me ask you this, just assuming just for a second here that on a public roadway fits here, which I know you highly dispute, but what, is this a strict liability offense or is there a culpable mental state required?
Your Honor, I would think there'd have to be some sort of a culpable mental state.
And
I mean, because you're actually telling somebody with regard to an action, there's some sort of that's kind of a difficult question to answer, because I think it's the nature of what's going on. If you hit somebody and you leave, obviously there's just a moral component of that that's wrong.
well, when a statute doesn't set one out, I'm going back to law school, one's inferred.
Well, Your Honor, if we're doing that, then we have to bring in the rule of lenity, where the interpretation of the statute has to go towards the accused, not the state. And that certainly didn't happen here. That certainly didn't happen here. In fact, I don't
agree. I don't think this is a strict liability statute.
But and that's, I think, why it makes it all the more troubling when the prosecutor brings up a case that not only did this court pretty much distinguish a few years later, but that the Supreme Court of Ohio, a year after it was issued, quite honestly, I would argue State v. Bennett didn't even apply to the facts of this case. Because in State v. Bennett, the prosecutor, which actually was in Wayne County as well, argued that the witnesses were in the police reports. And that's why this court said, no, you have to actually provide a list. Here, that doesn't even apply, because like I said, on 5 separate occasions, they were notified of the 6 witnesses that were going to be called. So I mean, with all respect to our judicial system, I can't believe this happened.
Well, Criminal Rule 16 says shall provide witnesses, correct?
It does say shall.
So your argument is remedy imposed by the judge. Remedy, sanction, or was it proper?
Well, it's 2 things, Your Honor. One, define list. If you are hand-delivered 6 separate items showing you actually subpoenaed those people, how is that not essentially the list? Because in fact, I would argue that's actually for a practitioner more important, because you don't have to guess that these are the people that you're going to call and you have to prepare for them. You have notice that these are the people that the side actually subpoenaed. So you actually provided more notice. So if we look at the intent of
Would you argue that the docket is the list?
What's that?
Would you argue that the docket is the list?
A docket could be the list if there is proof that as part of the docket, the other side was notified, and that was clearly the case. In fact, it's not even disputed that the copies of the subpoenas were provided. That's in the transcript that he admits, the prosecutor admits that he got it, which makes it all the more troubling that the whole purpose of the statute, as stated by the Supreme Court, and I think this court's referenced it too, is the purpose of Rule 16 is avoid the gamemanship. Well, if you know the witnesses, you know their addresses, you've been notified on 5 separate occasions that you're going to be called, and then at the last second go, well, I object because I found this case in 2012. We don't mention the Supreme Court case in 13 or this court's subsequent case in 15, 16, somewhere around there, that pretty much said, well, why don't we look at what we're really dealing with? If you look at the intent of the statute, it's clearly complied with.
Well, let's assume that what Judge Callahan said concerning the use of shall in the rule is what the court followed. What would have been the least restrictive sanction in your mind? If the court concluded there was a discovery violation here, was there a lesser restrictive sanction that the court?
Well, yes, sir. It's found in the 6th Amendment of the United States Supreme Court the right to a trial and the right to a defense. And if you look at the intent of the statute, was it complied with? And the statute was clearly complied with. What prejudice did the state have? None. Because they can't claim surprise. They've known about it. They knew about it.
So your argument is the court should not have imposed any sanction, even if they found a discovery violation?
Your Honor, first of all, I think it would have been an error for the court to find a discovery violation. So, I mean, if I'm arguing hypothetically, what should be the appropriate sanction? Well, what would put the state in a position of being prepared for trial? Well, they needed to be notified of the witnesses. Were they notified of the witnesses? Yes. Were they notified in a timely manner? Yes. 5 separate occasions. And the troubling aspect of that, Your Honor, is that when you go to a case and you go to a judge and go, here, this is the case, it's right on point, and you don't bother to either shepherdize the case to show, hey, there's subsequent cases that kind of distinguish this one, and you're citing it as good law, it's either reckless or it's intentional.
You're at 3 minutes, counsel.
Okay. I will reserve the balance for my rebuttal.
Thank you. Good morning, you'll have 15 minutes.
Good morning, Your Honors. Thank you. May it please the court and counsel, Andrea Uller for the state of Ohio. Initially, I'm going to address, I believe it was asked what the original citation was that was amended. And for my brief, it was 450615, which is prohibited acts. I did not have that statute with me to see what that would have entailed, but I believe overall the state is correct in that what is required by the amended statute that they cited under 454902 is that in the case of a motor vehicle accident or collision with persons or property on a public road or highway, the operator of the motor vehicle, having knowledge of the accident or collision, immediately shall stop the motor vehicle at the scene of the accident and remain at the scene. The state proved beyond a reasonable doubt met all of those essential elements. Mr. Pieronek does not dispute that at all times he was operating his motor vehicle upon a public road when his vehicle caught the overhead power lines, being the property that he collided with. Mr. Pieronek does not dispute that he was the operator or that he had knowledge of the collision. His testimony was that he saw sparks, or he looked in his rearview mirror and could see that he had caught the power line. And then because of the weather conditions, and he says that he contacted dispatch, then he proceeded to leave the scene, continue to his delivery destination, and then take his mandated half-hour lunch before eventually returning to the scene. But under those facts right there, we clearly fall within all of the elements of 454902.
Well, he stopped immediately. And
Yes.
remained at the scene because he called dispatch and waited for dispatch to get back to him. And there was no other person at the scene. I mean, nobody was injured. No other motor vehicle was there. No police officer was there. correct?
Correct, Your Honor.
So how does he not comply?
The rest of the statute actually then, you shall remain at the scene until you give the notification to, it goes through whether if there's a person injured in a collision, speaks about if there's a police officer at the scene.
Which there wasn't.
Yes, there wasn't. And so in this instance, he contacted his dispatch rather than calling 911. There was a witness to this, Mr. Leader, I believe, that he could have, if he didn't have the means, well, he had the means to contact dispatch, so I believe he had the means to contact, dispatch.
What if there was a big rock in the middle of the road or a deer? I mean, obviously, other vehicle was involved, no other person was injured. Does the person have to sit by that rock until a police officer comes?
I think in that instance, when there was damage, just in that instance, say, if you ran into the rock, you had damage to your vehicle, you would still have an obligation to notify police rather than your employer of the incident that happened so that the next person didn't also encounter that. But here, it was more than hitting a rock. You pulled down multiple power lines, caused the blackout of an entire community. But there was no violation, but for him choosing to continue on with his route rather than stopping and actually waiting for police so that he could discuss everything with the police and make the report had he been there and available and not left the scene, he would not be in violation of the statute. Essentially, it's the state's position that under 454902, the collision itself is to occur on the road. It does not require the object collided with also be located on the road. In addition, with reference to the cases that Mr. Pieronek cites to, as set forth in my brief, all of those cases are distinguishable. In Cutler, as this court has recognized, it was the car veered off the road and struck a mailbox. In Clark and Spence, it was a utility pole located next to the roadway. And in Mills, it was damage to fencing and patio furniture off of the roadway. And here we have, it is not in dispute that his vehicle never left the roadway. And when you look at this, viewing the light, the evidence in the light most favorable to the state, it cannot be said that the essential elements of RC 454902 were not proven beyond a reasonable doubt. The same analysis applies to Mr. Pieronek's second assignment of error, since it's also a sufficiency argument, and all of the elements of the offense were satisfied. With respect to, I know that counsel addressed assignment of error 4 next, where argues he was denied due process of law when his subpoenaed witnesses were prevented from testifying. The trial court has discretion in determining a sanction for a discovery violation, and this court's review of that matter is an abuse of discretion. In this matter, it's within the trial court's discretion, was in the trial court's discretion to prohibit all of Mr. Pieronek's subpoenaed witnesses from testifying, as Mr. Pieronek never provided the state with the witness list pursuant to Criminal Rule 16.
So let me ask you about that. What, if anything, happened with the state's motion to compel on that issue? And I'm assuming you're a little baffled because a motion to compel isn't part of the record. Would that be correct?
That would be correct. I'm trying to think back.
I guess I'm kind of maybe being a little unfair. If Section M, I'm not trying to be unfair, but if Section M of the discovery statute talks about a motion to compel, this case was continued 5 times. We don't have any dispute about that. And in that regard, I certainly understand the trial judge not wanting to continue it again. But isn't what happened here precisely the type of trial by ambush that Criminal Rule 16 is supposed to prohibit? It works for both sides, state and defense. The 2 prosecutors involved here, because it looks like there was one and then switched, because you can tell who the subpoenas went to. They knew all along. They didn't say anything at the beginning of trial. And then once the defense starts the case, then all of a sudden there's an issue. Isn't that what Criminal Rule 16 is supposed to be about?
I mean, does Criminal Rule regard, it was simply the witness list under Criminal Rule 16. They were relying on the State v. Bennett case law, and in State v. Bennett, which has not been overruled. There's the Ohio Supreme Court case and later case law, and it makes clear that it's within the discretion of the trial court to make those, to determine what sanction is appropriate for a discovery violation. But in this case, the trial court, the state simply on the grounds that there was no witness list objective, the trial court allowed a recess to try and find out why did the discovery violation occur, what happened here. As you indicated, the case had already been continued 5 times, but defense counsel and my reflection of the transcript never requested another continuance in this matter, which they could have requested. That is a less severe sanction.
Well, the state could have spoken to each witness prior to what the state would stand.
Yeah, that is another that the trial court could have determined was an available remedy. And in this situation, after looking at the language of the state Criminal Rule 16, that you shall provide the witness list, and the State v. Bennett, I do agree that the trial court based its decision on that, even though it did take the steps of reviewing, trying to find out what happened in this case. And that's where, again, defense counsel didn't request the continuance, but also defense counsel changed their argument to say, they were on notice because of the subpoenas. And when we talk about, I believe it was in Bennett, it was actually, the state only identified the witnesses in question by providing a copy of the police report. So there was no witness in Bennett, and the court said the rule requires the exchange of a witness list. After Bennett, then the State v. Alaska, which is this court, that's where you've provided that when, in that case, the prosecutor had provided a witness list. However, the witness in question, I believe, was different. At the time of trial, there had been a change in positions, and so you could not say that there had been a clear violation of Criminal Rule 16. In that case, the state had provided a witness list, and so then it turns into, the court, it's in its discretion to determine the sanction. And here it's clear that there was no witness list, and so because Bennett is not bad law, and because Alaska supports Bennett and as does the other case law, I think it's appropriate, and it was not an abuse of discretion for the trial court to choose to exclude all of the defendant's witnesses. Further, whether it would actually deny a defendant his right to a fair trial would depend upon basically the substance of what that testimony would have been. Here, the trial court allowed the defense to proffer what that testimony would have been. The proffer testimony was from some of the dispatch individuals. A prior trooper, I believe, who had done a diagram at the scene and said what he would have cited under. However, that ultimate charging discretion remains with the state, not with the officers. And so it's questionable if that should have been permitted had he even been able to testify. And so when you look at all of the testimony that was proffered, none of it actually goes, the App.No test requires basically that it be obviously material and relevant to the offense charged. We don't have that standard met here, and so there's no violation of any constitutional right. And although counsel indicated that the lesser sanction, is his constitutional right and denial of a fair trial, it's just request a continuance, or just the state was doing its part trying to advise the trial court on what it had available. Defense counsel is always open to that opportunity to advise on the case law as well. Respect to Mr. Pieronek's fifth assignment of error, that also goes to due process and a fair trial. However, is alleged on prosecutorial misconduct. The case that the prosecutor brought forth, again, is State v. Bennett, believed it to be good law. It remains good law. there's no proof that the state falsely represented to the trial court, that Bennett was the only case on point. And there's nothing here that actually rises to the level of prosecutorial misconduct. And when you look at that, it actually focuses on the fairness of the trial, not the culpability of the prosecutor. The prosecutor's remarks were proper. They did not affect any substantial rights of the accused. It was just the proper objection to the calling of witnesses who had not been previously disclosed on the witness list in accordance with Criminal Rule 16 and the prior case law. With respect to Mr. Pieronek's sixth assignment of error with the ineffective assistance of counsel, I believe that Mr. Pieronek has also failed to establish that his counsel's performance fell below an objective standard of reasonable representation. He's failed to show that but for trial counsel's failure to provide the witness list, the result of the trial would have been different. The state provided sufficient evidence to convict Mr. Pieronek of the offense charged. In addition, the evidence that's complained of was proffered, and it was proven or shown that there was nothing there that would have violated a substantial right, as it was not obviously material or relevant to the offense charged. If I have any time.
You have about a minute if somebody asked you hypothetically. What if he had hit a drone? Drone across the road, he hit a drone. Now what? What's he do now?
That would be an interesting scenario too. I believe if he's on the public road and we have, the proof that that accident occurred while you're on the public road and then you leave, I don't think anything in 454902 would, off the top of my head, change in that scenario. And that's where I was trying to come up, I could not find case law that was this exact fact scenario, and so I thought of, I'm driving down the road and strike a bridge, and that's above the roadway. Obviously, you have to turn around and leave the scene or go another route, but that's still, you're on the public roadway, you hit an obstacle, something that was there, that a collision occurred while you were on it, and you left the scene, you didn't stay, you didn't report, do all the requirements of the 454902. I would argue if you met all of those elements, that you had knowledge of the accident or collision, and you didn't stop and you didn't remain at the scene, that it would be proper to be cited.
Thank you, counsel. Your time is up.
Thank you. Thank you.
And 3 minutes for rebuttal.
Thank you, Your Honor, forgive me if I talk kind of fast. First of all, bridges have height limits, so there is culpability if a truck hits the bridge, and they should know the height of their truck, so the analogy is misplaced. The comment regarding the drone, the question by Judge Schaefer is very appropriate here. It's the reason why 4549.02 has never been used, as far as we can tell, and none have been cited by the state on a scenario like this because of the problems. Part of that statute talks about if somebody shows up and there's no one around, leaving your number. Well, how do you do that? You can't. That's why that statute didn't apply and why the court was incorrect and erred by not granting the motion to dismiss. With regard to the abuse of discretion standard regarding the discovery motion, I agree and I disagree, because I submit that the court didn't even follow the appropriate law at the time. If the court does not follow the appropriate law, this court reviews it de novo and not the abuse of discretion standard. So the first thing the court would have to do is determine whether the court followed the proper law. I submit he did not.
Let me ask you something, counsel. Has Bennett been overturned?
I would say it has been. Because you have subsequent rights, and the decisions, not only of this court, but from the Supreme Court, focuses on what's the appropriate method for those type of discovery methods, and you look at the circumstances. The judge in this case did not look at the circumstances. Trial court just said, okay, this is black letter law, and did it without looking at anything else. So I would submit that State v. Bennett, if it hasn't been specifically overruled by this court, it certainly has distinguished to the point of irrelevance. Furthermore, the irony is, if you even look at Bennett, the facts don't even apply to this case. Bennett was a situation where the state argued that their witnesses could be gleaned from the police reports. And that's when then Judge Belfant said, no, you have to provide them a list. Here, it's not like you have to guess who the witnesses were. They were served 5 times. So forgive my voice for going with a couple octaves, but that argument just doesn't hold merit. And the final thing I would really like to address, because there's 2 things. One, the state said they proved beyond a reasonable doubt that they succeeded by preventing defendant from really presenting a defense. But this half-hour lunch, it was established that that's ODOT requirements, and the computer essentially shuts down the semi once it stops for that mandatory break that is required by the Ohio Department of Transportation, and I think that's an actual federal requirement as well. To say that he stopped by to have a sandwich while people were suffering is such a mischaracterization of the circumstances that it is somewhat offensive. And the other thing I want to point out, regardless of the damage done, justice doesn't require you scapegoat somebody. It requires the laws be followed. And sadly, it appears that an innocent truck driver working as an agent for FedEx was scapegoated in the circumstances in which he did what he was required to do under his requirements, under his terms of his employment. And unfortunately, that wasn't able to be presented because of the witnesses that weren't allowed to testify.
Thank you for your.
Thank you.
Thank you both for being present today and providing the court with those arguments. We'll take the matter under advisement, issue a decision in due course, and the decision will be mailed to both of these on the day it is released. Of course, you can also check the Supreme Court of Ohio's website where the opinions are posted. Again, thank you for being here.